Here are 3 key things you need to know about the right to sue letters in California from EEOC or DFEH, which is Department of Fair Employment and Housing. The first important thing to know is that you have to have a right to sue letter before you can file your case, before you can file your lawsuit in court for most claims of discrimination, harassment, and retaliation against employers. There are a few exceptions, but generally, if you have a typical discrimination or retaliation case, you must have a right to sue letter, and you have to follow several important deadlines in order to file your case correctly, or otherwise your case can be dismissed later, several months later, 6 months later, or even right before trial if you don't follow these important rules and deadlines. Many people are not aware of these rules. Some lawyers even don't know about these rules, and many of them do, and they sometimes forget to follow these rules and deadlines, and then the case ends up being dismissed regardless of the facts of that case and regardless how strong that case otherwise would have been. The second important thing that you need to know about the right to sue letters is that you don't need one for all types of other employment cases that do not involve discrimination, retaliation, unlawful harassment, interference with medical leave rights, accommodation rights, disability rights, and a number of other rights. So, if you have a case for unpaid wages or unpaid overtime or unpaid meal breaks and rest breaks, or if you have a case for a breach of employment contract or a case for fraud or misrepresentation, and pretty much any other type of case that is not listed on EEOC or DFEH website or paperwork, you do not need a right to sue letter. You can still get one just to be on the safe side, but the point I would like to make is that many people, when they have an issue that EEOC and DFEH don't handle, they still go to their office, they submit their case, and DFEH and EEOC does not do anything about those submissions, and this turns out to be a big waste of time for everyone. You have to ask yourself, if you have a violation, EEOC, Equal Employment Opportunity Commission, what do they have to do with your claim for unpaid overtime? What do they have to do with your case for not receiving your final paycheck? They have nothing to do with it. They're all about unlawful discrimination, unlawful harassment based on age, race, disability, religion, and a few other protected classes. These are the types of cases they handle. Of course, you should be able to run your potential case by a good employment attorney who will tell you whether you have a case and whether you should be going to EEOC or DFEH to file a charge of discrimination and to start working on getting a right to sue letter. And this brings me to the third point. The third point that you need to know is that simply receiving a right to sue letter is just a formality. It says nothing about the merits of your case. It doesn't mean you have a strong case. It doesn't mean you have a weak case, or it doesn't mean that you have any case at all. Anybody can get a right to sue letter. EEOC and DFEH have very limited resources. They look deeply into very few cases. In majority of cases, what they do is they do a very minimal review of the evidence, and then they issue a right to sue letter, which basically says, look, the evidence here is insufficient, we cannot determine whether a violation took place, but if you want to pursue it on your own with a private attorney, here's your right to sue letter. This is what they do most of the time. This means that you should still review your case with an experienced employment attorney to determine whether it's worth pursuing. Because again, your right to sue letter does not answer that question. So keep these 3 important points in mind about the right to sue letter, and this should be very helpful to you in your employment case. Thank you.